NYAY PATHSALA is an online platform where we discuss various legal concepts and terminologies. It is designed for the benefit of the younger generation of the bar, the young advocates or the entrants, and anyone who is interested in various legal topics can subscribe to this channel. We invite all to be part of this community so that we can grow together. As a first generation lawyer, I was always amazed by the vast sales of books in a lawyer chamber. I always wondered how the lawyers used to look into each and every book which lined their chamber. It was until I embarked upon a journey as a lawyer that I truly grasped the significance of this bookshelves which were present in the lawyer chamber. After years of practice, I now stand before you all to share my understanding on some crucial jurisprudence concepts which are among the most essential tools in a lawyer's toolkit. In this video, we'll be exploring the concept of obiter dictum, ratio decidendi, par incuriam, and the doctrine of stare decisis, including how to read the judgment. If you are ever curious about how past decisions shape the present and the future of law, you are in the right place. Today, we'll look into these principles collectively. First, let us examine the doctrine of stare decisis. This is a term derived from Latin maxim, stare decisis et non quota movere. What does it refer? It refers to stand by the things decided, to uphold precedents, or to abide by the former statements and not to disturb that what is settled. Under the doctrine of stare decisis, lower courts are bound by the theory of precedent. First, let us understand from the point of view of the Constitution. Let us first look into Article 141 of the Constitution. Article 141 of the Constitution states that the law declared by the Supreme Court shall be binding on all courts within the territory of India. That means if a law is declared by the Supreme Court, it has to be bound to be followed by the High Court and the courts below the High Court. So let us understand what the judgment of a court consists. Broadly speaking, every judgment of a superior court has three segments. Namely, number one, the facts and the point at issue, the reasons for the decision. Number three, the final order containing the decision. And number four, it is the ratio decidendi of a judgment and not the final order in the judgment which forms a precedent. So we need to first understand what do you mean by ratio decidendi. The term ratio decidendi is a Latin expression which means the reason for deciding. We will look from the jurisprudence point of view the concept of ratio decidendi. In G.W. Patton's jurisprudence, ratio decidendi has been conceptualized in a novel manner. It says almost always used in contradiction to obiter dictum. We'll come to the concept of obiter dictum, but ratio decidendi, it embodies the rationale behind the judgment and constitute the crucial obligatory portion of the decision to be upheld as a precedent in future cases with comparable facts and legal issue. It establishes a precedent that judges use as the legal standard to resolve the legal matter stemming from the case facts, and this principle originating from the case unique circumstances is also known as case of ratio decidendi. To understand the concept of ratio decidendi, we have to look into the Constitution bench judgment in the case of Krishna Kumar versus Union of India, which was reported in 1994 SCC 207. Basically, the doctrine of precedent, which we called it, is always being bound by a previous decision, and it is limited to the decision itself and as to what it necessarily involved in it. Ratio decidendi means that the court is bound by the various reasons given in support of it especially when they contain proposition wider than the case itself required. It is said that the judicial authority belongs not to the exact word used in this or that judgment, nor even to all reasons given, but only to the principle accepted and applied as necessary grounds for the decision. We must understand that the enunciation of the reason or principle upon which a question before a court has been decided is alone binding as a precedent. In a judgment of the Supreme Court, it is said, a judgment, it is tried, and we are not to read it as a statute. When we talk about the ratio decidendi of a judgment, we talked about the reasoning which can be deciphered only upon reading the same in its entirety. The ratio decidendi of a case or the principles and reasons on which it is based is distinct from the relief finally granted or the manner adopted for its disposal. We may look into the case of executive engineer Dhenkhanal Minor Irrigation Division versus N.C. Buddharaj. It was a case reported in 2001 to SCC 71, where the concept of ratio decidendi have been elaborately explained. Let us now understand what do you mean by obiter dicta. The term dictum is generally used as an abbreviation of obiter dictum, which means a remark or opinion uttered by the way. Obiter dicta have no binding authority on another court, although they may have some persuasive value. Now, what is obiter dicta in a court judgment? Obiter dicta in a court judgment consists of the non-binding statements that do not establish new law, but can aid in understanding the case context and serve as a supportive tool for comprehending the ratio decidendi. Obiter dicta are considered persuasive. Why? Because rather than binding precedent, it provides a guidance or commentary on the legal issues without being the core basis for the decision. Obiter dicta, the court has said that it is more or less presumably unnecessary to the decision. It may be an expression of a judge on a particular point or sentiments, but it has no binding effect. The binding nature of a decision would always depend on the observation on the points raised and decided by the court, and not on the aspect which it has neither decided nor had occasion to express its opinion. The Supreme Court has held that interlocutory observation by members of a court during argument, while of persuasive weight, are not judicial pronouncement and do not decide anything. In the case of State of Haryana versus Ranbir, reported in 2006-5 SCC 167, you may look into it, where the Supreme Court has discussed the concept of obiter dictum. As a lawyer, we must remember that a decision, it is well settled, is an authority for what it decides and not what can logically be deduced therefrom. But normally, nowadays, even an obiter dictum is expected to be obeyed and followed, because it is ultimately an observation of the Honorable Supreme Court. The third phrase which I will be discussing with you is, what do you mean by par incuriam? Incuria literally means carelessness. Par incuriam means due to oversight, or it describes a court decision made without considering relevant statutory provisions or previous judgment. In practice, par incuriam means par ignoratiam. That means this is an English court's principle in relaxation to the rule of stare decisis. In one of the judgments, the Supreme Court has said, the quotable in law is avoided and ignored if it is rendered in ignoratiam of a statute or other binding authority. The Supreme Court has accepted, approved and adopted this concept while interpreting Article 141 of the Constitution of India, which embodies the doctrine of precedent as a matter of law. As I have already spoken at the beginning of this series, that under Article 41, any law declared by the Supreme Court is binding on all other courts. This rule of incuriam literally means judgment passed in ignorance of a relevant statute or a binding precedent, or that it is not possible to reconcile the judgment with a previous binding rule of a coordinate of a larger bench. And we must remember that par incuriam rule is strictly and correctly applicable to the ratio decidendi and not to obiter dicta. In relation to this concept, we must also understand what do you mean by sub silentio. A decision is considered sub silentio when a crucial issue wasn't addressed or discussed by the lawyers. This unaddressed the issue which could potentially influence the court's decision. In such cases, the decision doesn't serve as an authoritative precedent on the unargued point. We must look into the decision of MCD versus Gurman Kaur, which was reported in 1989 1 SCC page 101. In the decision, the Honorable Supreme Court has observed that when a point does not fall for decision of a court but incidentally arises for its consideration and is not to be necessarily to be decided for the ultimate decision of the case, such a decision does not form part of the ratio of the case, but the same is treated as a decision pars sub silentio. The concept of sub silentio has also been explained by Salmon on jurisprudence, and it has been reported in one of the judgments of the Supreme Court in Gunam Court case, which was reported in 1989 1 SCC page 101. We must remember that a decision which is pars sub silentio in the technical sense that has come to be attached to that phrase when the particular point of law involved in the decision is not perceived by the court or present to its mind. We may give an illustration of sub silentio where the court may consciously decide in favor of one party because of point A, say for example, which it considered and pronounces upon. Later on, it may be shown that, however, logically the court should not have decided in favor of the particular party unless it had decided the point number B in his favor. But point number B was never argued or considered by the court. In such circumstances, although point number B was logically involved in the facts and although the case had a specific outcome, the decision is not an authority on point B. Point B is said to be pars sub silentio. In the case of Gurman Kaur, which I have already referred as reported in 1989 1 SCC 101, the Supreme Court conclusively has held that not every passing expression of a judge, however eminent, can be treated as an excatenator of judgment, having the weight of authority. Similarly, it is held by the majority opinion in the Constitution bench of the Supreme Court in the case of Madhav Rao Jivaji Rao Scindia versus Union of India, reported in 1971 1 SCC page 85. In this decision, the Honorable Supreme Court has observed that it is difficult to regard a word, a clause or a sentence occurring in a judgment of the Supreme Court divorced from its context as containing a full exposition of the law on a question when the question did not even fall to be answered in the judgment. In another constitution bench of the court in Padma Sundara Rao versus State of Tamil Nadu, reported in 2002 3 SCC 5333, similar views have been expressed by the Supreme Court, where the unanimous decision of the constitution bench of the court opined that court should not place reliance on decision without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. There is always peril in treating the words of a speech or judgment as though they are words in a legislative enactment, and it is to be remembered that judicial utterances are made in the setting of the facts of a particular case. So we should remember that there is an expression called circumstantial flexibility. Circumstantial flexibility says that one additional or different fact may make a world of difference between two conclusions in a case. It is well settled as a canon of construction that a statute has to be read as a whole and in its context. Let us understand how to interpret a judgment or how to read a judgment. A decision is an authority for what it decides and not what can be logically deduced therefrom. If you want to read it in detail, you can read the judgment of Union of India versus Chajuram, reported in 2003 5 SCC 568. The Supreme Court have laid down certain proposition in regard to how to read a judgment in the case of TMA Pi Foundation versus State of Karnataka, reported in 2002 8 SCC 481. The courts said that you cannot read some such sentences from here and there to find out the intent and purport of the decision by not only considering what has been said therein, but the text and context in which you are said. For the said purpose, the court may also consider the constitutional or relevant statutory provisions vis-a-vis its earlier decision on which reliance has been placed. We may also look into the judgment of CIT versus Sun Engineering Works Private Limited, reported in 1992 4 SCC 363, wherein some further additional observation has been made by the Supreme Court. The Supreme Court has held that a decision of the Supreme Court takes its color from the question involved in the case in which it is rendered. And while applying the decision to a later case, the court must carefully try to ascertain the true principle laid down by the decision of the court, and not to pick out word or phrases from the sentence, from the judgment, divorced from the context of the questions under construction by the court to support the reasoning. In the case of Punjab Land Development and Reclamation Corporation Limited versus Labour Court, which is reported in 1993 SCC 682, the Supreme Court observed, this is very important, kindly pay attention. What constitutes binding precedent is always the ratio decidendi of a case. And this is almost always to be ascertained by analysis of the material facts of the case. That is generally those facts which the tribunal or the court in question itself holds expressly or implicitly to be material. And when you read a judgment, every judgment must be read as applicable to the particular facts proved or assumed to be proved. Since the generality of the expression which may be found there are not intended to be exposition of the whole law, but governed and qualified by the particular facts of the case in which such expressions are to be found. We all should remember as a lawyer that the case is only an authority for what it actually decides. For that, you may look into the case of State of Odisha versus Sudhanshu Shekhar Mishra, reported in AR 1968 SC 647. In that case, the Supreme Court observed, which is often quoted in various judgments of the Supreme Court, that a decision is only an authority for what it actually decides. What is the essence of the decision? It is always the ratio and not an observation found therein, nor what logically follows from the various observations made in it. If you look into the Constitution Bench judgment of the Supreme Court in the case of State of Punjab versus Baldev Singh, reported in 1999 6 SCC 172, the Supreme Court has held again that a judgment has to be considered in the context in which it was rendered. And again it said that a decision is an authority for what it decides, and it is not everything said therein that constitutes a precedent. The Supreme Court held that the binding nature of a decision would extend to only observation on points raised and decided by the court, and not an aspect which has neither decided nor had occasion to express its opinion upon it. We must remember that the observation made in a prior decision on a legal question, which arose in a manner not requiring any decision and which was to an extent unnecessary, ought to be considered merely as an obiter dictum. In case of ratio decidendi, the Supreme Court observed that the principle upon which the question before the court is decided must be considered as binding to be applied as an appropriate precedent. In the case of Padma Sundara Rao versus State of Tamil Nadu, reported in 2002 3 SCC 5333, the Supreme Court again stated, there is always peril in treating the words of a speech or judgment as though they are words in a legislative enactment. And it is to be remembered that judicial utterances are made in the setting of the facts of a particular case. As I have already told before about the concept of circumstantial flexibility, Circumstantial flexibility is that concept where it says that one additional or different fact may make a world of difference between conclusions in two cases. As it is often pointed out by the Supreme Court, that words and expression used in a judgment are not to be considered in the same manner as statutes or as words and expressions defined in statutes. In the case of Rajesha Prasad Mishra versus State of West Bengal, which is reported in AR 1965 SC 1887, the Supreme Court held in case of precedent that it stated that no doubt the law declared by the Supreme Court binds courts in India. But it should always be remembered that the Supreme Court does not enact or make laws. The conclusions of the court have to be read along with the discussion and the reasons given in the body of the judgment. To summarize the various legal phraseology today which we have discussed, let us remember that ratio decidendi is the precedent which we have to follow. Ultimately it is the ratio decidendi of the case which is important. Obiter dicta are passing reference. But when a Supreme Court makes an obiter dicta or a passing statement, that also has some persuasive and binding effect. Per incuriam is not binding on the courts because it is passed in ignorance of the particular law or a judgment of the superior court. I have also explained the doctrine of stare decisis and judgment passed in sub silentio. What we must remember that all this expression runs hands in hand. And to maintain judicial discipline, the court must always understand that normally a judgment or order of a coordinate bench has to be followed. If for some reason the court disagrees with the observation of the coordinate bench, it should always be referred to a larger bench. With these words, I conclude today's discussion. I hope that you will give your comments on the topic that you want us to bring to your notice, and we will always be grateful for giving us the support in our endeavor to bring these legal concepts to the people. I request all of you to subscribe to our channel so that we can be part of the same community where our effort will be to bring the legal concepts for the benefit of the young lawyers or the junior lawyers in the bar and anyone who is interested in the concept of law.